Our next class is Seinfeld Securities Fraud. Here to teach this class is Professor Andrew Jennings, who is the Susan Biddle Ross Memorial Professor of Law at Yada Yada Law School and Fellow and Lecturer in Law at Stanford Law School. Q&A will be moderated by Professor Carlos Chapman, the Serenity Now Foundation Chair of Business Law and Ethics at Yada Yada, and an Associate Professor at Washington and Lee School of Law. And without further ado, Professor Jennings, take it away.
Thank you, Dean Schill. As mentioned at the top, it'll be my pleasure to lecture today on Seinfeld securities fraud. I am the Susan Biddle Ross Professor of Law at Yada Yada Law School. My day job, again, is a fellow and lecturer in law at Stanford Law School, where my research and teaching interests lie in corporate law, securities regulation, corporates, and white-collar crime. I'm also the host of the Business Scholarship podcast, where I interview various business scholars in law, finance, accounting, etc., on recent work that they have done in business scholarships. It's available on all the major podcast services on your phone. It's also on my website. If you'd like to connect with me on Twitter, I'm at @AKJennings on Twitter. So today's agenda: what is securities fraud? What is Seinfeld securities fraud? There are a couple topics that we want to cover today, a few questions that we want to have answered by the end of this discussion. First, we'll take a little bit of a look at just what are securities and how are they regulated. It's hard to talk about securities fraud without these preliminaries out of the way. And then the specific Seinfeld-related questions we want to answer are two related to securities offerings. One is, what are the requirements for offering securities in the first place? When is selling securities actually not lawful, when it's illegal? Second, we want to ask about what is the role of truth in selling securities. Seinfeld is a show with characters who have a loose relationship with the truth sometimes. How might that come into play? And then insider trading will be a topic that we'll discuss, which is, when is it not legal to trade on certain information? So to take the first topic today, we are going to look at just what are securities regulated. George once told Jerry, remember, Jerry, it's not a lie if you believe it. I think we'll find that that's not necessarily good advice when it comes to securities regulation or selling securities. So what are securities? Securities are defined in two places in the federal statutes, one in the Securities Act in Section 2, and another in the Securities Exchange Act as well. The definitions largely overlap. And in general, they are investment-based financial instruments that take many, many forms. So we are probably all familiar with stocks, equity securities. We're probably familiar with bonds. We might be familiar with various derivatives like swaps and options. But from there, it can get pretty exotic. For example, mineral rights, investment contracts can take many different forms and might even include things like cryptocurrency or digital tokens. And then yada, 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 there are a lot of other things that are listed under the Securities Act as also being securities. Today, we'll be focusing on probably the most familiar form of security, which is stock security. So how are securities regulated? In the United States, there is a patchwork of state and federal law and state and federal regulators that are in charge of and enforcing securities laws. So every state has its own securities statute, I believe, except for Virginia. We call these blue sky laws. These laws actually predated federal securities regulation, and are largely, in some cases, preempted by federal law, but to this day, the states retain fairly overlapping jurisdiction with their federal counterparts in this regard. At the federal level, which is where we typically focus when we are teaching securities regulation in non-fake law schools, and where we'll focus today, we have a few major securities acts that are amended over time and have been supplemented over time. But those are the Securities Act of 1933. We call that the Securities Act, or sometimes you'll hear it referred to as the 93 Act or the 33 Act. That's an act that's really focused on how can securities be issued in the first place. If I am a startup company and I want to issue securities to help finance my business, or if I want to sell some bonds, how can I do that in a lawful way? And then we have the Securities Exchange Act, which was passed a year later. It is called the Exchange Act, or sometimes you'll hear it referred to as the 34 Act. It's really focused on what happens after the securities have been issued. We don't expect people to hold on to stocks and bonds forever. They're going to buy them and sell them. And so the Exchange Act, in a large way, is out there to regulate how securities are bought and sold. There are two other major acts called the Investment Company Act that, for example, handles the regulation of mutual funds, and the Investment Advisors Act. We won't be able to get to these today, but just know that they're out there. In terms of who enforces these laws and who enforces the regulations that are passed under these laws, we have a number of enforcers. We have the Securities and Exchange Commission, the SEC. It is the federal civil regulator for securities, and it can bring enforcement actions against those who violate the securities laws or its regulations. That might look like being sued in federal court or being subjected to an administrative proceeding before the SEC's own in-house judges. Many violations of the securities laws are also criminal. And so the DOJ, through the Maine Department of Justice and the U.S. Attorney's offices, will handle the criminal prosecution of securities violations. States also have their own regulators that very much are like the SEC in that they can bring enforcement actions. State prosecutors can prosecute violations of state securities laws. And of course, if you are the victim of a fraud, you may have a right of action to become whole, to be compensated. And so the securities laws are also enforced by private litigants, people like you and me. An important idea behind securities regulation, though, in the United States at least, is the idea of disclosure, or it's sometimes phrased as sunlight is the best disinfectant. The general idea is that we don't pass judgment on whether securities should be bought or sold, whether they're good investments. We leave that up to the decisions of investors. We merely say that if there is proper full disclosure, investors are going to be in a position to make that decision for themselves. And so disclosure in securities regulation is a mix of both mandatory and voluntary disclosure. And that will be a little bit related to some of the topics that we'll talk about in just a moment. So this takes us to our first big topic, securities offering fraud. And I have a quote here that I think will make a little bit more sense as we move along, which is, you just yada yada'd over the best part. No, I mentioned the bisque. So we'll see what that means in just a moment. Our episode for this discussion is Non-Fat Yogurt, Season 5, Episode 7. For any folks who maybe weren't able to catch the clips or watch the episode on Hulu recently or have forgotten, here's some of the key facts. In the show, in this episode, we have a frozen yogurt chain in New York City. It appears to be fairly small. We know that Kramer has invested some money in this chain. It's not clear how much he invested or from whom he bought the securities, but most likely he would have bought some shares in this business. We know that there's a founder / majority owner, most likely, who works at one of the locations. We see him working behind the counter. He's also the father of little Matthew. And if you have seen the full episode, you know Jerry gets in some trouble for using bad language around little Matthew because little Matthew really looks up to Jerry and emulates him. Perhaps the most important thing, though, is that patrons love the yogurt of this chain because it's both delicious and, even better, it's fat-free. And so you can have just as much as you want without consequence. But that's not really the case. Jerry and Elaine come to suspect that the yogurt is not, in fact, fat-free. They take a sample to a lab. The lab conducts an analysis and finds that, in fact, it does have quite a bit of fat. And so there's some evidence that patrons like Jerry and Elaine have been eating it as if it's consequence-free. And so that's had some negative implications for the health of the patrons. We see that even then mayoral candidate Rudy Giuliani may have been a victim of this fraud, although there's a little bit ambiguity there in the show. So this gets us to our first lesson for Seinfeld securities fraud, which is before securities are offered, they must be registered or exempt from registration. This is a basic rule for offering securities. Every securities offering must be registered with the SEC. It must conform to certain required disclosures. That is, unless there's a valid exemption from registration on which to rely. So here is the rule under the Securities Act, Section 5. Registration is required if any interstate commerce is used to sell a security through a prospectus or otherwise. So if I am selling a security using the telephone or the internet, or mail, or I'm driving across state lines using interstate highways, or perhaps if I'm sending a telegram. All these things are going to implicate interstate commerce, and I must file a registration statement and have it be in effect at the time that I offer that security, unless there is an exemption on which I can rely. Now, there are two big categories of exemptions on which we can rely. There are exempt securities, securities that themselves just don't have to be registered. There's no requirement to register them, at least federally. And then there are exempt transactions. These are securities transactions where the underlying securities themselves may or may not be exempt from registration, but the overall transaction doesn't have to be. And so this is a yada yada grab bag as well. The Securities Act Section 3 lists a lot of exempt securities, but a few that are kind of top of mind are federal and municipal bonds. The Treasury Department or your city government don't have to register securities with the SEC before they issue bonds, certain short-term notes, bank securities, yada, yada, yada. A really important exemption, though, is what is called the interstate exemption, which I have highlighted here, which basically says that if I am selling securities only to people within a single state or territory, and I, the issuer, whether I'm an individual or corporation, I am a resident myself and I'm doing business within that state or territory, then I am exempt from federal registration. I might have to register under state law perhaps, but in terms of the Securities Act, I am exempt from registration. And then there are exempt transactions. And again, this is a yada, yada, yada situation where Section 4 of the Securities Act lists a number of different exempt transactions, but two that I think are relevant to maybe our analysis here are transactions by persons other than an issuer. This is the company selling the shares, an underwriter or a dealer. These are often banks or broker-dealers who are hired to help market the securities. And then transactions by an issuer not involving any public offering. So in this case, for example, let's say that I buy some shares. Somebody says, Andrew, I really like the looks of those shares. I want to buy them from you. We would be able to rely on this exemption number 1 to trade them between ourselves because I'm not an issuer, I'm not an underwriter, and I'm not a dealer. And you probably are not either. And then transactions that are not public offerings. This is a heavy area for securities practice, particularly transactional practice. Companies often do not want to be engaged in a public offering, especially these days, because there are pretty heavy disclosure requirements and process requirements that go into that. And so we see companies often in the venture capital space, startups would prefer to offer securities in a private offering that doesn't have the full registration requirements or disclosure requirements that a public offering would require. So this, I think, allows us to analyze some of the facts of this case and look and see whether those securities should have been registered in the first place. So the first question is, was there a public offering? It's probably unclear, but I think odds are that there was not a public offering. There's some indication in the show that Kramer may know. The founder of this chain, it looks to be fairly small. So any investment probably would not be broad enough to qualify for a public offering. Let's say that this was a public offering, though, just for the sake of argument. If so, was it a public offering that was interstate in nature? So did Kramer just buy the securities as part of an interstate offering? The odds there are probably yes. This is a small chain. Kramer lives in New York. The chain is in New York. So probably it was part of an interstate offering. It's possible perhaps that somebody lives in Jersey and works in Manhattan and discovered the yogurt and wanted to invest him or herself, which would blow this interstate exemption. But let's just say that probably, yes, there was an interstate offering exemption available. There's a little bit of a secondary question about whether New York would require registration. New York is actually a little bit of an outlier when it comes to this, and that they probably would not have required a yogurt business and its securities to be registered. They do require some other types of securities to be registered, but here we're probably okay. There are some other New York requirements that we won't get into that may come into play in this situation, but registration is probably not one of them. And then the question is, all right, well, apart from all these things, did Kramer purchase the securities from an issuer, underwriter, or dealer? Most likely not an underwriter or dealer. This is a small chain. They probably didn't hire a big bank to help market the securities, but he probably did purchase the securities from an issuer. For example, he bought them directly from the founder of the business. So this factor standing alone would suggest that there needed to be registration, but there probably wasn't a public offering. And if there was a public offering, it was probably interstate in nature. So the founder of the yogurt business would have been able to rely on the exemptions available from registration. But let's just say, for the sake of argument, that he was wrong, that there was a requirement to register these securities. Maybe some of my assumptions about some of these facts are off. Well, if there is a requirement to register, there's strict liability for failing to do so, which means that even if I thought that, I had an exemption to rely on, I had good lawyers tell me that I had an exemption to rely on, if I'm wrong, I'm still strictly liable for being wrong. And the idea there is that you really incent people to be careful about either registering or making sure that they have a valid exemption to rely upon. And so what are the consequences for failing to register? Well, depending on whether the investor still owns his or her shares, there can be damages or rescission. So for example, if Kramer invested $5,000 to buy shares in the business, and after the fraud was exposed, after we realized that it was actually not fat-free yogurt, the value of those shares fell to $1,000. Kramer, if he still owned those shares, could force the issuer to buy them back for the original $5,000, even though they're not worth that anymore. Of course, if they appreciated and he didn't want to do that, he could keep the shares. So this really is to protect the investor. There's also the possibility of damages. So if Kramer had already sold his shares, he'd gotten rid of them at a loss, he would be able to come back and say, okay, well, I sold my shares for $1,000. I bought them for $5,000. You need to pay me $4,000 in damages because you failed to register. This leads us to our second lesson for this Seinfeld securities fraud, which is issuers and others are sometimes liable for material misstatements and omissions. So what does that mean? Let's take these three important words step by step: material, misstatements, or omissions. What is materiality? Materiality is a mixed question of law and fact. It drives so much of daily securities practice, whether it is a transactional practice or a regulatory practice or litigation practice. Our best standard for articulating what is material is referred to as the TSC Industries case, which says that something is material if it has a substantial likelihood that a reasonable investor would consider the true or the omitted information important in making a decision. Now, that doesn't mean that the true or omitted information, had the investor had that information, would have led to a different decision. It merely means that it is important in making a decision. So for example, if the owner of the business told Kramer in selling the securities that the yogurt is delicious and maybe didn't include information about all the health factors, that might be omitted information that would be important in making a decision. Perhaps Kramer would still invest otherwise. In terms of defining a misstatement, this is a fairly obvious one, I think. If a company is required or allowed to make a statement, then if it says something that is false or untrue, that's a misstatement. Omission, I think we can really think of as yada yadaing over the best part. This is something that comes up when a company is required, say by SEC regulation, to make certain disclosures, and it fails to do so. Or we omit information that's required to make another statement true or not misleading. So for example, if the owner of the yogurt shop had told Kramer, this yogurt is delicious, people love it, and it's healthy, that could possibly be true on its face. It seems that it is true that people love it, it's delicious, and there might be some health benefits to some of the yogurt. There might be some probiotics in it, there might be some vegetables in it, so there might be some health benefits to eating this yogurt, but it omits the fact that the yogurt is fatty, and so people may want to limit how much yogurt that they consume. And that would be relevant to an investor who's buying shares in a company that is making this yogurt. So was this fraud? Was Kramer the victim of material misstatements or omissions? We're probably looking at misstatements here because there was an affirmative misstatement that the yogurt was fat-free. I think this is a question that's interestingly kind of tied into whether the misstatement was material to customers as well. So the fat-free status seems to have really driven some customer behavior. Jerry and Elaine, for example, bought a lot more frozen yogurt from this store than they otherwise would have because it was fat-free and implicitly consequence-free. And so the revenue, the profits of the store were probably higher than they otherwise would have been had this misstatement not been done. And I think that would make it also material to investors as well. If the yogurt is delicious and fat-free, we would expect that the profits would be higher than for yogurt that happens to be delicious but still fatty, because people would probably eat less of it. So this is an interesting case where I think the customer and the investor interests are sort of aligned. These are distinct but interrelated claims. So for example, customers might have a false marketing claim and investors like Kramer might have a securities fraud claim. So what might be some of the consequences for material misstatements or omissions? Well, Section 11 of the Securities Act provides for strict liability for material misstatements or omissions contained in a registration statement. And there are a few defendants like officers, directors, and bankers who can assert a good faith defense, but for the issuer, it's strict liability. So if you are a plaintiff, that is a good standard to be operating under. We established earlier, though, that there probably was not a registration statement in this case. So there is a secondary option, which is Securities Act Section 12, which provides for liability for any material misstatement or omission in a securities offering, even if there isn't a registration statement. But that is a burden shifting liability test. And so plaintiff like Kramer would probably prefer to be under Section 11. But if that's not available because there was no requirement to register, there was no registration statement, Section 12 might offer some help in terms of getting damages and that sort of thing. Of course, there is a criminal penalty for violating the Securities Act. Section 77X of the Securities Act provides for up to 5 years in prison for willful violations of the act, in addition to various fines and other consequences. So at the end of the episode, we see here little Matthew is very angry at Jerry because Jerry has exposed the fraud. The family's yogurt business is not doing as well as it did. And so this is a detriment for the family. But perhaps Matthew should have been angry instead at his father because his father was the one making these material misstatements to both investors and to customers. This takes us to our final topic of the day and for this lecture, which is insider trading. If this is allowed to go on, this is not a society, this is anarchy. And our lesson or our clip for that is the stock tip, which Professor Chapman also mentioned earlier. It's a very early episode, season 1, episode 5. I believe this came out in 1990. I was thinking the other day about how old I was at the time. We won't get into that, but it was a while ago. So a few of the key facts, in case folks haven't been able to see the clip or watch the episode recently. George has a friend, Simons, who knows a guy, Wilkerson. Wilkerson made a fortune in the stock market. Now he's got this new thing, a merger, but he wasn't supposed to say anything. A company called Centrex. They got a new technique for televising opera. You want to get in, Wilkerson will tell you when to sell. George does want to get in. He invests $5,000. This compares to Wilkerson's millions in the stock. Jerry invests $2,500, but when he sells the stock, it goes down. But when the stock goes down, he goes ahead and sells, and he loses about half his investment in the process. George sticks with it. He makes about $8,000 in profit. It's a Hyundai. And Simons and Wilkerson, of course, clean up as well. So our final lesson, some tips are too hot to trade because some tips are unlawful insider trading. Now, there's no federal law expressly against insider trading. It is a largely judge-made law. It's a theory of fraud under the Exchange Act Section 10B and the SEC's Rule 10b-5, which serve as general prohibitions against securities fraud. And the basic idea of insider trading liability is that we may not trade based on material non-public information if doing so would breach a duty to somebody else. And so material non-public information, there's that word material again. It is information that would be relevant, that would be important to an investor making a decision whether to buy or sell a security. Non-public information, of course, is just information that is not available in the market to anybody who wants it. We often see insider trading couched in terms of fairness. Is it necessarily fair that some people have information that others don't and they're able to profit on that? There is a strain of this, but we also do tolerate certain types of trading that aren't implicitly fair. For example, we want to incent people to investigate and analyze available information and to maybe develop new information and to trade on that increases the efficiencies of the market. So fairness itself is not necessarily the touchstone of insider trading liability. It's instead breach of duty. Do I have a duty to someone not to disclose non-material public information or not to use that material non-public information or in MNPI to my own benefit? And the folks who have that duty are most often going to be insiders. The traditional case would be corporate directors or employees or officers. There are also constructive insiders like lawyers and accountants and bankers, consultants who have a fiduciary duty to their clients, who obtain their clients' MNPI in the process of representing them and are duty bound not to take that information for their own profit. So just to look quickly at Rule 10b-5, it's a fairly short rule, but in relevant part, it is unlawful for any person, directly or indirectly, to use the interstate commerce to engage in any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person in connection with the purchase or sale of a security. Now, this is a pretty broad phrase. It prohibits a lot of fraudulent conduct, and judge-made law over time has found that it incorporates what we now know as insider trading. Now, insider trading itself is a very broad jurisprudence. We won't have time to get into all of the nooks and crannies today, but there are two types of insider trading liability or scenarios I'd like to talk about because they do have, I think, something to say about what we saw in the Seinfeld episode with George's tip, and that is misappropriation and tipper-tippee liability. In misappropriation liability, we have somebody who owes a duty to another, so let's say an employer or a client, to maintain confidence of that person's information and not to misappropriate it for their own profit. That person instead takes that information, trades on it, and makes money, and then perhaps is found out and might have some consequences to pay for that. This is the case United States v. O'Hagan, where the facts are that a partner at a big law firm learned that his firm was representing a client in a merger. The partner himself wasn't working on that merger, but he learned of it through his employment with his law firm. He took that information, he traded in the relevant securities and made about $4.5 million. And eventually he was caught and prosecuted. Now, we don't even necessarily have to have the person who breaches the duty making a profit for there to be liability for that person or for others. Let's take the example of somebody who breaches the duty and then perhaps sells the information to somebody else. This person is not trading. This person might be the person who trades. But if this person is still trying to obtain a personal benefit as a result of breaching his or her fiduciary duty, he or she is still liable for insider trading. And this person who, aware that person A breached his or her duty and aware that person A received a personal benefit for doing so, also becomes liable for the fraud. Now, this doesn't even require that person A receive some sort of tangible benefit like cash or property. It can really just be the idea that person A really likes person B, wants to give person B the gift of information, which can be used to turn a profit in the stock market. That is also personal benefit to person A, because if we think about it, it's really economically no different than if person A traded on the information him or herself, took that cash and handed it to a friend or relative and said, I love you, here, take this money. And so that is the case Dirks v. SEC. And so here we have the tipper who provides the tip and the tippee who receives the tip, and they're both liable for securities fraud as a result. The Dirks case is fairly similar to Salman v. United States, and Salman is very similar to our scenario in Seinfeld. In Salman, we had an investment banker who became aware of his investment bank's clients engaging in certain mergers. The investment banker gave his beloved brother information which he knew that his brother was going to trade on. And his brother gave his brother-in-law information as well, which he knew the brother-in-law was going to trade on. And so the facts are that everybody knew where the source of the information was coming from. Everybody knew that the information was being provided in a breach of the investment banker's duty to his clients and to his firm's clients, and everybody traded. So there was a personal benefit of gifting information down the line, and all of these people, even the most remote tippee, were held liable as a result. So where does that leave us with Seinfeld? Was there fraud in George receiving and trading on the tip? First question we need to ask is, did Wilkerson owe a duty? We don't have all of the facts, but it seems contextually like the case would be that he does owe a duty. We know that this company is developing a fairly new technology, suggesting that it's a startup. We know that Wilkerson has millions of dollars in the stock, which might suggest that he's an early investor, might have some informational rights. I think the most probative fact that he might owe a duty is that he knows of the pending merger. And not only does he know of the pending merger, he's continuing to receive information. And so would be able to convey that information on to George or to Simons if they want the perfect time to close out their position. So odds are he does owe a duty, and he has breached it by telling other people about this information. Now, second question, did he disclose this information for personal benefit? For example, was he making a gift to his friend Simons? Here it looks like the answer is probably yes. It looks like he and Simons do this quite a bit. They might trade back and forth information, in which case there would be a personal benefit. There's probably at least a gift. Simons gave the gift of information to George and so forth. So we're probably satisfied on the personal benefit prong as well. Now, that speaks to, I think, the liability of Wilkerson and Simons. What about the remote tippees, George and Jerry? Yes, I think they would be liable too. They knew about all of this. George himself is our source for this information. He relayed the information to Jerry that Wilkerson has this hot tip. There's a merger happening. He's not even supposed to talk about it, but he does anyway. And if you want in, he'll let you know when the right time to trade is. So George and Jerry seem to be aware that there was a breach and aware that there's a personal benefit, so they would also be liable. Even though Jerry is fairly far down the chain, he too would be a remote tippee who is liable for the fraud. And so there are, of course, civil penalties for insider trading. It's a form of securities fraud after all. And of course, there are also criminal penalties. So violations of the Exchange Act, which is the act under which Rule 10b-5 was promulgated, can lead up to 20 years in imprisonment and other fines and penalties as well. Now, probably George and Jerry are not going to get 20 years if they are discovered, given how much they invested, but they might spend more time in prison than they did in the end of the show. So that is Seinfeld securities fraud. I would welcome your questions, and I would just remind you that we have a special event tomorrow that is available to register for, and look forward to your questions from there.
All right, so the first question we have is, if I'm a sole proprietor and ask a single person, no one else, if they want to invest in my business, is that a security?
Well, it's going to depend on a few things. If you are bringing that person on as a silent investor, you probably have a partnership of some sort, as Professor Chapman referenced. If you form an entity, perhaps you might issue some membership interest in LLC or shares in a corporation. But if you're just a silent investor, that's probably going to be a security. It could be an investment contract. But if you're going to actively work in the business with that person, typically if there's a partnership, that would not be considered a security. So if two lawyers are going to form a partnership together, that would not, their partnership interest wouldn't be treated as a security.
All right.
There are a few distinctions there based on control, but that's kind of a general rule.
Okay, so our second question, if I sell a non-registered security to a resident within the same state, but they end up being a resident of another state, is the company protected? That is to say, what obligations are on the investor?
So the liability would flow for a failure to register when there wasn't a valid liability would flow to the issuer. And so the seller of the securities, if I just bought the securities and I sold them to somebody and I'm not an issuer, I'm not an underwriter, I'm not a dealer, most likely I wouldn't have any liability there. There are some particular rules about what happens when people move, when do the securities come to rest, but probably as an investor, you would be okay in that context.
All right, and so this question deals with a different show. So in Billions on Showtime, a flight attendant on a private jet overhears information and then makes a stock purchase based on it. Is that a crime or not?
So I haven't seen Billions. It is on my summer watch list, but I think that this is a pretty classic scenario. So if the flight attendant was of disclosure, for example, if his or her charter company said, not to share it, he or she is probably going to be liable for insider trading. Now, if it is a commercial airline, just to play with the hypothetical a little bit, and a flight attendant just happens to overhear some big executives in first class who are being careless with information and talking about an upcoming merger, and he or she trades on that information, it probably is okay. And a classic example of just where the line is if you're in a restaurant and the people in the booth next to you are a couple of big CEOs and they're being loud and they're talking about the deal that they're about to do, and you're just another patron, you can probably trade on that information because there wouldn't be a personal benefit involved there.
Okay, so our next question, other than civil or criminal penalties, what damages could Jerry be liable for, if any?
So Jerry, it's interesting. Jerry actually lost money, but that doesn't reduce his culpability for the insider trading. Now, conceivably, I think really the only consequence he might face would be a civil enforcement action by the SEC or potentially a criminal action by the U.S. Attorney's Office. Conceivably, if Wilkerson was a senior director or executive at the company and somebody discovered that he had been insider trading, shareholders who were harmed by that, or purchasers who are harmed by that, or sellers who are harmed by that, could sue him individually. But probably for Jerry, the only consequence he would face would be through public enforcement by the SEC or DOJ.
Okay, so I mean, this is a good one because I always have this question too. There seems to be fairly heavy responsibility on the tippees in cases of insider trading. If George had only passed on the stock tip to Jerry, but hadn't told him about the inside info he received from Simmons, would Jerry still be guilty of insider trading? I.e., how responsible is the potential tippee for probing the source of the information or tip?
Well, so of course, with the proviso that none of this is legal advice, I think that if George had just said, I hear that the Syntex Corporation is doing great things, it's a good stock to buy, and Jerry had no reason to believe that that information was conveyed to him through a breach of duty or that there was a personal benefit involved, Jerry would probably be okay. As to kind of the due diligence requirement that we might have for acting on what might be a little bit of a sketchy tip, I think that's a little bit of a harder question, probably more of a fact and circumstances question. But if, you know, it's just a tip, this is a good stock, I hear it's good, that probably itself would not be enough to create tippee liability for Jerry.
Okay, next question. How easy or difficult is it to detect insider trading?
So this is a really good empirical question. I think there's debate on it. I think the SEC, with its partners, its self-regulatory partners in FINRA, the Financial Industry Regulatory Authority, and the stock exchanges, is getting better at it as they're able to use certain technological tools. Probably there's a lot of insider trading that goes on that is not detected. It can be fairly difficult to know where the trading is happening. Oftentimes after a merger or certain big events happen in a corporate life, statistically anomalous trading will be identified, particularly if it's trading in options where maybe one day, on most days, a company has 1,000 options trade on that company's stock, and then right before a merger, somebody buys 50,000 options. That looks a little bit suspicious. And FINRA and the SEC can investigate, okay, well, who is trading there? They can follow the money, but sometimes that can be dead end. So I would never suggest that anybody insider trade. I think that your chances of getting caught are pretty high, apart from the immorality of it. But it's a little bit unclear just how often it happens and how often it's caught.
All right, so our next question is, what role do states play in securities enforcement?
So this is a good question too. So states have overlapping authority with their federal counterparts in enforcing in the security space. So often can't require that things be registered if they are federally covered, but they do have their own version of 10b-5, which is a blanket prohibition on securities fraud. And so what the states often do is not necessarily enforcement involving big public companies, but localized frauds that might be promissory note schemes or Ponzi schemes or real estate related schemes, things of that nature that might involve things like we saw in this episode of Seinfeld, where Kramer bought some securities in a small business and it turned out to be based on a fraud. And so states are very active, actually bring more cases by number, at least, than the federal counterparts, but they will probably focus more on local types of issues, and oftentimes those might be smaller frauds, but that still are quite significant for the victims of those frauds.
All right, so next question, is a secured loan a security? What if the loan is syndicated to multiple separate parties?
So this is, I think, something that securities and finance practitioners debate about, whether a syndicated loan is a security. There's a good argument to be made that it is, depending on the circumstances, whether it's being used to finance kind of capital purposes, capital improvements or acquisitions, or whether it's just being used for sort of a line of credit, that sort of thing. That's a hard question. I think in practice, they are treated as not securities, and that's sort of the industry practice. But conceivably, we can make a case that they are.
Okay, then we've got two more. Why are the state laws referred to as blue sky laws? What is the origin of the term? What states have the most onerous state requirements that are separate and distinct from the federal securities rules?
So I believe there is a historical explanation for the blue sky term. I want to say there was and don't quote me on this, I'm probably mangling a little bit, but I think there was a newspaper article or op-ed in the 1800s that said that certain securities that were being offered were worthless. They were worth as much as the blue sky Kansas, I believe. And so that's mangling the history a little bit, but I think that's the gist of what the origin was. It's the idea that unscrupulous promoters are selling securities that are essentially worthless. And that's where the phrase kind of emerged from, as states took the initial lead in passing securities laws. In terms of what state is the most onerous, I'm not sure that the right way to think about that is in terms of registration requirements, because many companies don't need to register with the states due to some federal legislation that came out somewhat recently in the 1990s. And so that's a little bit of a hard question. I think in terms of enforcement, there is a variety of different approaches that states take. I would say probably the states that stick out to me as particularly aggressive or active on the enforcement front are Alabama, which is pretty active in enforcement. Texas is very active in enforcement, and the New York Attorney General's office is also known to be fairly active, and the Massachusetts Secretary of the Commonwealth is also a fairly active securities enforcer. So there is variety in the enforcement activity, but I think also states try to coordinate as much as possible on the front end, so that to the extent that they do require filings on the front end or have other requirements, they do try to work together. There's a Uniform Securities Act that a lot of states follow that provides a degree of uniformity as well.
And we've actually got two more if there are time.
Okay.
You know, this next one, I think this is a good one. What are the challenges in registering a security? Why not just register everything? Then he also says, can anyone just throw together an exchange for anyone to participate in?
So registering securities is a pretty in-depth process. So if you want to go public, for example, that's an example of a time that you need to register the shares in your company before you offer them to the public. There is a lot of liability that goes into that. There are a lot of disclosures that have to be made according to SEC rules. It's a very expensive process to pull those disclosures together. You need several years of audited financials. And so if the rule was that every security must be registered before it can be offered, we wouldn't really be able to start a lot of new companies that have a need for capital. So Silicon Valley probably wouldn't be able to get off the ground if the initial offering of securities required registration. So it's a little bit of a mix between, if you want to offer securities to the public, you have to agree to take on these extra responsibilities, and you'll get access to the public's capital as a result. But if you want to restrict how you raise money to certain exemptions, if you want to focus on just private offerings, then your disclosure requirements are much lower, but you are restricted in from whom you can take the money. So that, I think, is the answer there. And in terms of starting an exchange, exchanges we didn't talk about today, but those are also regulated under the Exchange Act. And so there is a pretty arduous process to register an exchange. There are a lot of requirements around how exchanges are governed and how they operate. And so it wouldn't probably be something that you could start on your own.
Okay, and then our final question for real, I think, is I seem to recall that insider trading didn't apply to Congress. I thought there was a change in the Obama administration, but then that was changed shortly thereafter with no fanfare. So can Congress insider trade again?
So there was a gap that was long recognized in Rule 10b-5 and insider trading practice, that there's some ambiguity as to whether members of Congress or their staffs owed a duty of confidence or confidentiality to the government. Conceivably, a member of Congress might receive information that is not public, but that is useful for trading. Perhaps people in the executive branch even more likely to receive that sort of information. We can imagine somebody working at the FDA who might know about whether certain drugs have been approved or not would have very valuable information. In, I believe, 2012, and Dean Schill is actually an expert on this, so I would maybe refer you to some of his writings. I believe in 2012, a law was passed called the Stock Act, which did extend 10b-5's insider trading precedents to members of Congress and their staffs. And I believe it was amended shortly thereafter, but the core of the act is still there. I think it's been a little tested. There's one member of Congress I can think of who was recently indicted and convicted of insider trading, but I believe that was because he was insider trading in the context of his fiduciary duty to the company, and not in terms of his being a member of Congress. But long story short, there is an act that extends those prohibitions to members of Congress and their staffs.
All right, I think that's all for Q&A, and we've only got about 3 or 4 minutes left. So is Dean Schill still around?
Of course. Well, thanks, folks. Just want to make one final plug for our event tomorrow with Jennifer Keeshan Armstrong, the author of Seinfeldia, How a Show About Nothing Changed Everything. That's going to be at 5 p.m. Eastern. It'll be an hour long. She's going to give a talk about her book and then do a raffle to give away 5 copies that she's going to sign by hand and annotate, meaning write some additional notes in the margin that didn't make it into the publication edition. Anyway, so we're really excited about that. It's a special fundraiser for our charity partner. And so I'll quit hitting you over the head with it, but if you haven't had a chance yet, do encourage you to donate $20 or more to the Legal Services of New York City COVID-19 Relief Fund. There's a link in the Q&A, and you can also find it on our website and just by Googling. And again, in order to be eligible for the raffle, please do that. Kick in $20 by tomorrow morning, July 16th at 8 a.m. Eastern. Thanks so much. We look forward to seeing you tomorrow and or next week. Bye-bye.